So, good morning, everybody. Today we have the honor and the pleasure of having here two great experts of climate change, namely Annalisa Savaresi and Jacques Hartmann, who do not need any presentation on my part.
Thank you very much, Giuseppe, for that kind introduction, and indeed thanks to the University of Trento for hosting us to give this keynote, which is part of a PhD school of a GreenDeal-NET, a project that brings together a number of European universities sponsored by the European Union and includes, of course, my own university, the University of Eastern Finland, that is co-host of the PhD-NET school for our PhDs together with the University of Heidelberg. It's a pleasure to be here and address with you a topic that is at the heart of my research, as many of you may know already. So the plan today is for me and Jacques to really go through what we see as a major development in this subject area in the context of the EU. The findings that we will provide are based on some of our published paper and some of unpublished work that I will mention. To get us started, though, I will, for the first thing, introduce the definition of climate litigation. I'm sure you all know this already, yet it's important that we get an understanding of what we mean by this term. In this presentation, and indeed in most of the things we write, the use of this term is that is standardly made in the literature. So we're talking about lawsuits raising questions of law or fact regarding climate science, mitigation, or adaptation. Now, confusingly, the literature and the data sets that exist out there in the world conflate a lot of different things. Lawsuits that are formal in nature and have been filed before courts, but also various types of complaints that are filed before judicial or non-judicial bodies at the national, international, subnational, regional level. So a bit of everything. If you're curious about this, I highly recommend the reports that are prepared by the Grantham Institute at the London School of Economics. I don't really need any introduction. I'm told that they are the most read publication of the Grantham by far. So they are really a valuable source of information with the limitations I've just mentioned. So what we are trying to do with this presentation today is really to dive into this data and unpick some of this litigation that is particularly relevant from a perspective of the EU and its member states. What I would also add is that the Grantham has itself done a report, which is the first report I know of this litigation, which is already a couple of years old. So look that one up as well if you are curious. It was prepared for the European Forum of Environmental Law Judges. Now, having premised that, I'll give the floor to Jacques that will give you an overview of a paper that he wrote already 2 years ago with Mark Wilders. Feels like a long time, Jacques.
It does feel like a long time ago. Well, let me start by echoing Annalisa's words. Thank you very much for the kind invitation, and I'm very happy to be back in Trento. So it's an exciting time to be a climate change lawyer. There is ongoing litigations before the International Tribunal for the Law of the Sea, the International Court of Justice, the Inter-American Court of Human Rights. I'm not going to be talking about any of that. I'm going to be talking about the European litigation. And I'll start first by looking at what's been taking place in the European Union, and then I'll look at the Council of Europe. And I like to put these on, the slides on, because I know you won't do this, of course, but some of my students have a tendency to confuse the Council of Europe and the European Union. So it's always useful to remind ourselves that they are distinct organizations, even though they have the same flag, which, by the way, the European Union borrowed from the Council of Europe. And as Annalisa said, I'm drawing from an article from 2022, which is called Protecting Rights to Climate Change Litigation Before European Courts. So let's have a start by looking at the European Court of Justice. There's been two cases. One was the People's Climate Change, which was brought by 10 families, some of them all over Europe, some of them also outside Europe. And they were targeting the legislative package of the European Union that set the climate targets for up until 2030. So that was the Emissions Trading Directive, the Greenhouse Gas Regulation, and the LULUCF regulation. And essentially what the claimants were saying was that these were insufficiently ambitious. They were reaching for a 40% reduction in greenhouse gas emissions from the European Union. They were also had another claim for damages pursuant to Article 340 on the Treaty of the Functioning of the European Union, where you can ask both for pecuniary and non-pecuniary damages, and they were asking there, they had kind of two avenues. It didn't really matter because the case was unsuccessful. The other case that went to the European Court of Justice was the EU biomass case, and they were charging the Renewable Energy Directive, also known as RED II. It also sets a target for, in this case, energy consumption, and it said that there you could use renewables such as forest biomass, trees, branches, bark, as a source of renewable energy, and the claimants in this case were challenging that. And we don't need to go so much into the details of the two cases because both of the cases were struck down. The European Court of Justice followed this very well-established Plowman doctrine, which is a doctrine that's been there since 1963, which essentially says that if an individual is seeking review, then you must be directly an individual concerned by the legislative act in question, which is an impossible standing requirement, which means that individuals and NGOs are never successful in these kind of cases. Not all was lost though, because as we saw in the first case, they were asking to have more ambitious climate targets. The European Union actually changed its climate targets with the Green Deal. So we come somewhat closer to what was asked for the claimants. And there was also a review of the Aarhus regulation. So the Aarhus regulation and Aarhus Convention gives you a right of access to environmental information, and it has, amongst others, yes, that's what we're looking at here. It was first implemented in a regulation from 2006, which again made it very difficult for individuals to get standing before the court. It was then amended in 2001, and we are giving something a wider access to what's called internal review. And what that does is that individuals or NGOs can, under certain conditions, ask for an internal review. So that means that the Council of Europe is reviewing its all administrative acts, and it's only administrative acts.
Council of Europe?
Sorry, I did the mistake now that yes, sorry. Yes, the European Commission, very importantly, reviews its own acts. And that has given a little bit of broader access. So what happens here is we go to the European Commission, we ask for an internal review. They will then make an internal review, which of course is very important because it's very difficult for individuals to judicial review because of the Plowman test. If the European Commission then does not find there's been a mistake, then you have potential avenue to go to the European Court of Justice. So it gives you a slightly easier access to get to the court in these kind of cases. Do you want to add something?
I will take over in talking a little bit about the fact that there have been a number of applications for internal review, as you may not be surprised to hear, because of the restrictions associated with the implementation of the Plowman test by the European Court of Justice. Applicants have tried to use internal review. And in this connection, it's important for us to note that a number of such requests have been made specifically in relation to the EU taxonomy regulation, and other related instruments that are part of the Green Deal reforms, which is really important because we are looking at an evolving area of practice where internal review is being used in new ways by environmental applicants in order to force the European institution to reflect on their own decisions and their own legislative action. Now, the case, especially you see on the slide, is one of the ones that have excited the applicants in different ways. We are here looking at an entry point potentially for applicants to intervene in the legislative process in ways in which they were not authorized to do before. The other entry point that is particularly interesting for us to consider at this stage is that under the reforms that were introduced in recent years in EU climate change law, member states have to produce national energy and climate plans. These plans are akin to earlier instruments that were implemented in the previous decade of EU climate lawmaking. At the same time, what is more interesting about these plans is that we have now new tools, potentially, to scrutinize what member states do in order to achieve their national objectives under EU law and targets, but also the contribution to the 5 dimensions, so to say, of the energy union. This is really crucial. We had litigation and contentious activities vis-a-vis the plans that were submitted also in the earlier decade. At the same time, there was not the same level of litigation and activity in that decade that there is today. What is very interesting for us to see, for example, and if you go to the next slide, Jacques, please, is that there is already ongoing litigation against the NCPs that have been submitted, for example, by Spain and Romania. But I know for a fact that there is a lot more of this litigation coming, not only before the courts of the EU, but also before national courts. And this is really important. It's really important because we are seeing new judicial activism in areas where previously there has been little. And if you ask me, this is what really matters, because these are the plans that member states prepare in order to make good of their commitments under national, international law in many ways, because this is really the implementation of their obligations. So the fact that this judicial and scrutiny is being applied for the first time in this area, potentially as a result of this litigation, is really interesting. And if you speak to the NGOs that are active in this area, this is a big new field for them to look at. I should also say that at the University of Eastern Finland in particular, we have a couple of projects that are looking specifically at this judicial activity, and we are quite excited. One is for attraction, and my colleague and supervisee Maju Mahonen has recently written a report that specifically looks at access to justice in relation to this specific area of litigation. And of course, there is another project that started now called Retool, where Joanna Setzer and others, together with myself, will be looking at developments in new climate change litigation. So lots more to come. An interesting area of practice. It's fair to say there isn't a lot of literature out there yet because the practice is so fluid, but watch this space, there's lots more happening.
So yes, that's what we had to say about the European Union. Lots of interesting cases coming on, especially under the taxonomy regulation. Now we'll turn to the European Union, and this is, I'll just explain why the distinction that I mentioned before is so important. The European Union, of course, is a supranational body that can make legislative decisions that are directly binding in the member states. And that means for litigation is potentially very attractive, because if you can basically get access to the court and challenge one of those pieces of legislation, you can potentially change the law, or they have it declared null and void in 27 member states of the European Union. It's just very, very difficult to get there. The Council of Europe is not a supranational, it's an old-fashioned international body that drafts treaties, and then states can sign up if they want to be parties to these treaties. And of course, the most important treaty is the European Convention on Human Rights. And there's been cases here as well. In fact, quite a lot. There are currently 3 cases pending before the Grand Chamber. 6 cases have been adjourned. So when the other cases were sent to the Grand Chamber, the lower court of the European Court of Human Rights decided basically to wait and see what happens in the Grand Chamber decision. And then we have 3 cases that have been declared inadmissible. And they kind of challenge a little bit the standard definition of climate change litigation, but I'll get back to that. So the 3 cases that are currently awaiting treatment by the Grand Chamber, they've already had the oral hearings, is Verein Klimasanering and others versus Switzerland. So that's a case brought of a group of, I think you can say, all Swiss ladies. You're nodding, I can see, so you take responsibility for the classification here. And they rely on Article 8. Sorry? Positive discrimination. So they rely on Article 2, the right to life. They rely on Article 8, respect for their private family life and their home. And they further complain that they have not have access to court within the meaning of Article 6 of the convention, because they went all the way to the Supreme Court in Switzerland and was turned down. The Swiss court actually made a very interesting pronunciation. They said, what you're asking for, you have to ask the politicians for. It's not something you get from a court, which raises issues also about what you can and cannot get from a court. Now, interestingly, these ladies, the Swiss ladies, claim that because they're old ladies, they're particularly affected by climate change, such as increasing temperatures, which is interesting. And I'll get back to why that's interesting. The second case is Carême versus France. That is a former French mayor who says, or he claims, that the French authorities have taken insufficient measures to combat climate change. He also relies on the right to life and Article 8, the right to home, among others. And then the last case, the case that has gotten the most publicity, is Agostínez and others. And that's been brought against Portugal and another 32 member states of the Council of Europe, which is in itself a little bit unusual. It's not the only case we'll see that's been done that way, but it's also unusual in the sense that the applicants have not exhausted domestic remedies. So to go to the European Court of Human Rights, you normally have to go through all the domestic complaints procedures before you can go to the European Court of Human Rights. They have not done this, partly because they would have to exhaust the domestic remedies in 33 countries, which would take a long time. But they're also arguing that their case is too urgent for them to do so, which might be true, but it also gives the court a very easy way of getting rid of this case. Whereas in the Verein Klimasanering, they have exhausted the domestic remedies. Now, the reason that I said that the first case was interesting is that the ladies from Switzerland says that they are particularly affected because old ladies suffer more from climate change. And in Director Agostínez, they say young people are more affected because we have to live with the effects of climate change, and among others invoke the mental suffering that you have from living with climate change. So these cases are currently being heard. There was hearings in Klimasanering and Carême in March last year, and the Grand Chamber heard Director Agostínez in September last year. So we are still quite some time off a decision. When we have had a decision by the Grand Chamber in these 3, we can call them trial cases, we have another 6 cases that are awaiting and that have been declared admissible. So we have 2 Italian cases where they rely on Article 2, the right to life, Article 8, but also Article 13, lack of access to a remedy, and Article 14, which is a discrimination and which you can claim in relation to other rights. And again, they say that they have their human rights combined with the lack of measures taken by their national states, and in this case also other European Council of Europe states are breaching their human rights and rely both on their human rights, but also in conjunction with the Paris Agreement. And the other applicants do that as well. Then we have Müllner, which is against Austria, which is a not more interesting case, but it's a more directly affected case because the applicant suffers from a medical condition that means that he has to sit in a wheelchair if it gets above 30 degrees Celsius. So that's quite clear, the connection. He also relies on Article 2, 6, 8, and 13. Then we have 2 Greenpeace cases against Norway. They are complaining that they tried to stop an oil drilling application in Norway. They were unsuccessful. They brought their case to the European Court of Human Rights. And like the others, they also rely on Article 2 and the right to life, Article 8, and 13, lack of remedy, and 14, discrimination. Then we have Subsiste and others versus Austria. And they are brought by a group of individuals from France, Cyprus, Belgium, Germany, and Switzerland. Again, there's the same rights they're relying on, Article 2, but also Article 3, torture, inhuman, degrading treatment, and Article 8, right to home, and 14, discrimination. And then we have the last one, which is Engels versus Germany. 9 young people have brought this case, relying on Article 2 and Article 8. So all of these cases, we are relying on standard human rights. They're arguing there's a posture obligation on the member states to do something, and they say you're not basically doing enough, or you are not actually implementing the obligations that you have. Then we have 3 cases that have so far become declared inadmissible. So they've been struck down. They've been struck down by a single judge of the European Court of Human Rights. So we don't really know very much about why they've been struck down. On the face of them, some of the cases look similar to the other cases, where others look like they are a little bit further out on our, let's say, list of climate change litigation. So the Human Being and Others versus the United Kingdom, that was brought by a non-profit organization that was running a campaign against factory farming. And they said that factory farming, so industrialized farming, contribute to climate change, and they rely on Article 2, 3, and 8. That was struck down. So that was probably a little bit further out in terms of there was not such a direct claim. Plan B Earth, that's an NGO, but also individuals. And they say that the UK has failed to take measures to tackle extreme man-made climate change. They also rely on 2, 3, and 14, and Article 6, the right to a fair trial, and 13. And they do that because their case was struck down in domestic courts in the UK. So they said they have not got access to court, a bit like in the Swiss case. And then the latest case to be struck down is Asociación Instituto Metaboti, sorry for my Spanish. And that was also a non-profit organization which is running a campaign against animal exploitation. So a little bit similar to Human Being and Others versus United Kingdom. So it seems that the court is willing to take out climate change litigation, but if you are arguing that certain points of industrial farming contribute to climate change, that they seem apparently to be a step too far. So this is just an overview of the case law that we have in terms of what articles they're relying on. So as you can see, everybody's relying on Article 2, the right to life. 2 cases have relied on Article 3, the prohibition of inhuman and degrading treatment, but they were both not successful. And then some cases have relied on Article 6, the right to a fair trial. Most of them rely on Article 8 as well, so the right to respect for your home. And the argument is commonly that people cannot live in their homes because of forest fires, for instance, or because of increasing heat. 13, the right to an effective remedy, that's been mentioned in a few cases. And then a few cases also relied on discrimination, which under the European Convention, you can only rely on in relation to other provisions. Now, what I was planning to say a few words about, if we still have time, is about responsibility of several states, because some of these cases have been brought against almost all the member states of the Council of Europe, which is very unusual. And then we go into the standard rules of state responsibility, which of course we find in the articles of state responsibilities that had been developed by the International Law Commission. There are quite few rules in the articles on state responsibility. And that's partly because the rules of state responsibility that we have in international law have been developed in litigation. And it's actually quite difficult to bring litigation against several states, especially before the International Court of Justice, which has been the place where most of these rules have their origin. But it says in Article 47 that where several states are responsible for the same international wrongful act, the responsibility of each state may be invoked to the relation to that act. So that is quite interesting. So that seems that there is a scope under general international law to rely on the responsibility against several states. The court does sometimes, the European Court of Human Rights does sometimes rely on the rules on state responsibility. Not always very faithful to the rules on state responsibility. Other times it does apply them like they were intended. But there are some cases. So I've just put on the slide as SIVA, so the articles of state responsibility not enough. We have a set of guiding principles which was cited in the Portuguese case, which is this document that's been developed by a group of scholars that explains how the rules on state responsibility should be extended, especially in climate change, but also in other environmental cases where we have more than one state contributing to the international law. And we have also a fair bit of case law for the European Court of Human Rights, where it has held more than one state responsible for the same international law. And I'll just give you this rather long quote, basically. So in the Salis versus Greens, which is about the human trafficking, it says it's true that the cases can occur where an identifiable element of an injury can probably be allocated to one of several concurrently operating causes alone. But unless some part of the injury can be shown to be severable in casual terms from that attributed to the responsible state, the latter is held responsible for all the consequences, not being too remote of its wrongful conduct. So it seems that you can hold all states individual and fully responsible for the violation. So we should also say that the cases that go before the European Court of Human Rights are positive obligation cases. So they're alleging that a state has not done enough, for instance, to live up to its commitment under the Paris Agreement, which are different, for instance, to some of the civil claims that are being brought, where they say an individual company is responsible for climate change for a certain percentage of historical emissions. That the court doesn't necessarily have to get into. You can just say you haven't done enough, for instance, by adopting a specific target. Now, what does that then mean? What can we get out of the European Court of Human Rights? Well, unlike the European Court of Justice, it cannot strike down domestic law, so we can't get this kind of countrywide effect that we could under the European Union, the European Court of Justice. It can give just satisfaction to the injured parties, which is normally, well, it can be just a declaration that's been a breach, and it can also be a monetary compensation. And of course, the decisions of the court are binding on the states. But how far the court will go in terms, it doesn't normally go very far in saying what states have to do, but it will just find a violation, for instance, of the right to life or Article 8. And then you wanted to say something conclusion.
Yes. Where does this leave us? This is a very important question, because this has been a bit of a tour de force, and we realize that we've thrown a lot of information to you. So we are basically here talking about three distinct avenues of litigation: the avenue before, the courts of the European Union itself, and potentially whatever comes out of that litigation affects all member states simultaneously. So you see the attraction of that kind of litigation. And this is why, in spite of the Plowman tests, applicants persevere, because this is a very potentially effective way to get the legislative change and reforms that they are looking for. National courts, of course, can take on one member state at a time. So it's a long game to get to collective increased ambition in the EU, if this is what you want. Of course, it is nevertheless extremely important, and if you ask me, potentially even more effective avenue, because you're really hitting whatever it is that you are not pleased with in the plans at home, where the lawmakers actually have the power to make the change that you want, rather than waiting for national lawmakers to implement EU law, for example. When we're talking about European Convention of Human Rights, we are in a completely different game. As Jacques was saying, we are looking at a court that has a lot of visibility, that can, of course, name and shame states, and also issue some measures that are, however, when compared with the other two courts, clearly limited in their efficacy in addressing the outcomes that climate litigants typically look for. At the same time, I believe the European Court of Human Rights has a role to play, even though not as prominent maybe as we may be led to believe. We have to remind ourselves that this litigation before the European Court of Human Rights is not happening in isolation. The European Court of Human Rights has a rich history of jurisprudence in dealing with environmental matters. It does so in a very conservative way that the court is confident with. When you speak to activists in the Council of Europe, they tell you, this is not what the court and the convention were designed to do. So we have to operate within the scope of what that instrument enables us to do, which is typically to ask a state to legislate vis-a-vis environmental harm that has repercussions on the enjoyment of human rights, and B, to enforce whatever laws that are adopted in this connection to prevent harms that are associated with the enjoyment of human rights. It makes sense, if you ask me, having watched the jurisprudence of the court for a long time. I do understand why we're trying to push the boundaries here. There is a lot of very urgent questions on the table here. So I'm not for a minute disputing the validity of the cases before the European Court of Human Rights. I'm just saying they're part of a constellation of activity that we've tried to capture in this presentation that has similar motivations, but we have also to be realistic about what we can achieve in these different fora and for what purposes. And I think I'll leave it to that. Thank you very much for listening and happy to take any questions. Thank you so much.
Thank you. Thank you very much, Annalisa and Jacques. You gave us in 40 minutes material for maybe a 2-year course on several aspects, not only dealing with legal issues, but as it is clear also with many other aspects of the topic you dealt with. I must say that really I'm impressed by the institutional issues, information, and the climate change and human rights and settlement of disputes topics that you have touched in a so short period of time. However, I think that you count on the fact that all of us are experts on this topic, and so I have to forgive you, but at the same time, I must say that we were, I must say, I was really impressed by the enormous amount of issues that are involved. I knew it, but as an international lawyer, I'm much more dealt with what Jacques was referring to at the very beginning. So the ICJ cases, Inter-American case, Inter-American Court case, and ITLOS. So the fact that in the European Union, as it often happens, there is another word that is much wider than what we usually deal with is another important sign, I would say, of the level of integration within the European landscape, not the European Union, but within the European landscape of the repercussions of climate change issues. But I'll ask whether there is any question, and so I don't want to invade the time allotted to. Yes, please introduce yourself. And
1 second.
Just a moment.
I'm Alessandra Miccolis. I'm from the Faculty of Economy, actually, but it's an interdisciplinary faculty. But for me, this topic is totally new. But I was wondering if before of this law, who had the responsibility about this act? I mean, this law is new, and before it, what happened? I mean, what there was before? But probably it's a really stupid question. I don't know.
No, it's not. It's actually quite an interesting question.
It's a very important question because what I always tell my students of climate law,
I thought that one had
climate law is a new creature. It's a new area of law. And in this connection, it's in the process of evolving. And what we are doing right now, in fact, through this litigation, is to develop the aspect of the law. This is typical of environmental law. It's nothing new here. Once we have established that something is harmful, like greenhouse gases, one of the things we do, of course, is to regulate the production, emission, the activities that generate this source of pollution. But the next thing we have to do is to decide who is responsible for the pollution and what that means in practice. Do we put them in jail? Do we make them pay fines? Or do we license this activity? This is standard practice in environmental law. Climate change law, you can argue, has got there a bit slowly and a bit late. The reason why this is because the pollution is so diffuse. There's so many polluters. It's very hard. It may sound counterintuitive, but it's easier to regulate discrete polluters, big polluters. Big industry, easy to regulate. We know who they are, and they are heavily regulated already normally. But diffuse pollution is actually extremely difficult and politically controversial. So politicians, lawmakers that rely on elections to be appointed have a difficult time going there. But this is where this is pushing them. Litigation will not resolve this problem, but it is a tool that we use in order to push for legislation. It's a long game. Hopefully we get there before the planet catches fire, but it's this is what is happening in a nutshell here.
I'll just add, so you asked if the law is new. No, the law is not new. So what climate litigation tries to do is to take all kinds of bits of laws they can find, basically, and try and apply it in a climate perspective. They do that in private law, and they do that in public law, and they do that in public international law. So in this case, they have taken either EU legislation, the fundamental Charter of the European Union, which has many of the same rights that we also have found in the European Convention of Human Rights. The European Convention of Human Rights is from 1950, so it's by no means a new piece of law, an international treaty. But what it has, and also EU law can do, is they can evolve with time, basically. And sometimes we have here this critique, well, this is never what the European Convention of Human Rights was intended to do. And you could say, well, actually, none of the things that it does today, it was intended to do. Because what the European Court of Human Rights does, they interpret the European Convention from 1950 in light of modern day conditions. So, for instance, the right to privacy or right to email privacy, that nobody thought about in the 1950s, that you couldn't hit your children in school, they probably thought about, but they didn't think it should be unlawful in 1950s. But the European Court then says, well, do other European member states regulate this? If they regulate that, then they will have a closer scrutiny to what member states, and slowly this evolves the human rights, which are actually very short pieces of text. I think the Article 3, the prohibition of torture, is 8 words or something like that. And in those 8 words, the court then over decades have interpreted, among others, this thing we call a positive obligation, which means if there is a danger that is foreseeable, then the member states of the Council of Europe has to take action to prevent that danger. And that's essentially what these states, these applicants are arguing. So they're taking an old law, basically, but applying to a new thing, but relying on lots of established case law. And that's the new thing about it. But a good question.
Yeah, sure. Yeah.
I do have an online one
questions?
as well.
Yes, please.
Should we have the online one first?
Maybe, yeah, why not? But I think Jacques has to read it.
So it's from Rosa Fernandez.
because I don't get it.
What are the chances of having a case before the EU CJ that will not be declared inadmissible? And is this maybe linked to the application of the Aarhus Convention and the EU Human Rights Charter?
I think the chance is very small, I must say, because the Plowman test has now stood the test of time since 1963, and the European Court doesn't look like it wants to budge at all on that. So, and the internal review gives you a small avenue, but only for administrative decisions of the bodies of the European Union. So it's not so much we can review under there. So yeah, I think it's pretty much futile to go to win a case. But I think also we lawyers have to remember that it's not always about winning and losing cases. That's how most lawyers think. Oh, we lost this case and then nothing comes of it. That's not necessarily true. As we saw in the applicants in the first case before the European Court of Justice, they wanted more ambitious climate targets. We now have more ambitious climate targets. The other things that they clearly wanted was more publicity. They got that. And we can see also Durango Agustinus is probably the case most likely to be thrown out of the European Court of Human Rights, has gotten more publicity than any other case together. And suddenly journalists are calling me and they're calling my colleagues and says, what's this thing about climate change and taking states to court? So there's many ways you can win these cases, and they're clearly winning on some ways that they were thinking. And in fact, I don't think the lawyers that brought the two cases before the European Court of Justice thought they were going to win. They brought it for other reasons.
And you can win also when you lose sometime. Any other question?
Right, so I found this point about the Aarhus regulation to be quite interesting. And how does that connect with more like specific articles on access to justice in particular pieces of legislation? And can you use that in the absence of access to justice article to sort of challenge EU legislation?
This is thank you for that question, Robin. This is exactly what Mayu worked on in her report, because the question of access to justice on environmental matters under EU law is a big question that is coming up in a new guise in this specific context. So what Mayu does in her paper, and I really encourage you to find it and read it, I'll share it with you all, is to identify where this question may be raised and how. And the Aarhus regulation revised clearly has improved the status quo. We have to remind ourselves that the Aarhus Compliance Committee found the European Union in violation of its obligations under the Aarhus Convention. And the revision of the Aarhus regulation was exactly related to that. If you ask the NGOs, what we have, even after the revision of the Aarhus regulation, is not good enough. So what the paper that Mayu wrote does is to identify potential avenues for remedying the perceived shortcomings of the revised regulation in climate change law. There is a bit of a fashion, as you may know, to suggest specific provisions on access to justice in discrete instruments of EU environmental law. This is a new thing. Didn't happen before to the same extent, possibly. But of course, you are free to disagree. We are just here, of course, again, looking at a very large set of reforms that have been passed very recently. Nobody can keep up with the Green Deal. We are trying. With the GreenDeal-NET, we're trying, but there's so much new legislation coming our way. I really think that Mayu's paper has done a very good job in trying to identify what are those opportunities and what is really happening in practice out there beyond the advocacy arguments that are being made, which are, well-known and very loud, but what is actually happening in terms of change and opportunities.
Marco, yes.
Thank you very much for your talk. It was impressive. I have two questions, but the first one is very quick. Are there any cases before the European Court of Human Rights where provisional measures were requested? provisional.
As far as I know, nobody's
provisional measures. No.
No.
No. Okay, so that was just out of curiosity. The second one is, do you think the fact that people are going before the European Court of Human Rights, of course, requires to create a linkage between human rights protection and environmental matters, climate change? So we need always to think of climate change policies as being related to harm to human beings, preventing harm to human beings. Do you think this push, this habit of going to court where you can go, it's a problem of access to justice as well, do you think that might create a distortion in the way the policies are implemented? The fact that the policies are constantly or mainly interpreted in terms of potential harm to human beings.
Do you want to answer?
Thank you, Marco. Yeah, I think that this is also something I was wondering. Sometimes maybe people, I'm talking about anyone, could think whether climate litigation is the best way to pursue certain aims. I think that, you will tell me that there is literature on this. I'm sure about it. But, you know, as a lawyer, sometimes we always think whether there is sometime the problem, the issue of abusing law in order to get to certain results. But I leave you the floor. Thank you.
Yeah, I don't think anybody's claiming that this is the best way to solve climate change. I think people are arguing that this is basically necessary because politicians for decades have not been doing anything. So I don't think anybody would claim this is the best way by far. I also think the legal tradition comes in. So in the common law countries, they have a much stronger tradition for this judge-made intervention in the law, where the continent, we don't, and especially in the northern European states. And we saw that in the Swiss case where the Supreme Court says what you want, you have to ask the politicians for. So there's a very clear difference in the cultural tradition. One of the things that I always find a bit fascinating is that when they were implementing the European Convention of Human Rights into domestic law, in the UK, they had a debate about this, and they were very afraid of parliamentary sovereignty, and they didn't want judges to be able to strike down a law. So they wrote that into the Implementation Act. And if you look at the debate in continental Europe, nobody was afraid of the judges striking down the laws. They do all the time. But they didn't want judges in many places to create new laws. So in some places, they put that into the Implementation Act. So we clearly have a very different perception of the role of the lawyer in the various domestic systems. I think from an international perspective, we are used to, the European Court of Human Rights is often accused of being dynamic in its interpretation of the law. But from an international perspective, there's nothing unusual about that. I think we're probably just better aware of what takes place before the Strasbourg Court.
Just briefly also, because we're running out of time, I don't for a minute suggest that litigation is the way out of this quagmire. What I'm saying is that it is playing a part, maybe a disproportionate part, and is being saddled with unrealistic expectations in engendering the legislative change that we undoubtedly need if we want to get to net zero. I do not want to bore you with the details, but we all know we're not on track to achieving the goals enshrined in the Paris Agreement. And the goals in the Paris Agreement have been determined by science, not by political agreement in that connection. So we really have to try and do the best we can. And litigation is one of the many ways in which we can try and get there. But if you ask me, the better way would be to have good laws that are properly implemented, and the judges then step in to do their job, which is to do the end of the process, which is to oversee implementation and enforcement, rather than telling the lawmakers to make better laws. We are where we are with this, and I think that when we look at these issues as academics. We have the job of being critical of what we see and not just accept everything that comes out of the databases of the NGOs and advocacy fora. So we have also a role to play and the responsibility to speak truth to power and to be rigorous about what we do. It is a very fascinating and chaotic world. So I hope that this was helpful to try and make sense of it all.
We have time for another last question.
I think what you just said compliments for this excellent presentation, which is giving a good overview and also weighting the various options. What you last said probably is too optimistic to make sense of it all, but you made a lot of sense of many things, I think, and I would start from the point you made with good laws and bad laws, because here it's a way of participation in a way. It's a way of confronting politicians with specific interests, and as you said, using the courts as a platform for media attention, for also for lobbying. And I think this is very important. Of course, the courts defend themselves and saying you are not admissible, and you are. But I also like very much that you didn't forget about the national courts, because a lot of things can happen there. And also in our interdependent world, in particular in the European Union, in the Council of Europe, there's much attention to what national courts also say. And this is a way of pushing the borders a bit further. And it comes to my mind the judgment of the German Constitutional Court regarding the legislator not being permitted of putting the burden, the higher burden of climate change regulations on the future generations, but to do a kind of proportionate distribution of this burden from here to 2050, I think, or 2030. And I think this is very important. And in Italy, we had a constitutional amendment going in the same direction with intergenerational justice, which can be very useful also here. And so I think there is room for improvement, and the climate litigation is really a nice push in this direction. Thank you.
Thank you.
Can I just add on that? Because I actually thought the reactions to the German Supreme Court decision by the German politicians was interesting, because they thought it was very useful. To some extent. So they went out and said, well, we have to do this. So sometimes you have to take decisions that are unpopular to combat climate change. But if you can blame it on the courts, the politicians are in a much easier position.
Thank you very much. Thank you. Thank you for everything. Maybe there is a very last. If there is time. There is no time, but okay. Never mind. So I just to thank you all for these, also for these lovely debates, and thank our keynote speakers for many reasons, but also because now I understood really why last year in July, when I was in Geneva, one of the most important headlines was that of the death of tens of old people because it was too hot, and of course everybody thought that it was related to climate change. So I think that we have to think about intergenerational issues, but we have also to think to the eldest. Also maybe because I am going to this age, so I have a personal interest in it. I have a personal concern, as you say. So thank you very much. Thank you again, and